Hello, wonderful viewers. Welcome to the Law Lab. Here we unpack and dissect everything legal. Today we'll continue our discussions on public international law, specifically the Law of Treaties, and the series that we've begun on the Law of Treaties. Today we'll be looking specifically at consent to be bound by a treaty and how a nation state can express such a consent to be bound by a treaty. In our previous episode, we saw how the VCLT would require that any person that is representing the states for the purposes of negotiating and concluding or finalizing a treaty must possess full powers. In some instances, we saw that a person may have full powers to adopt only the text of the treaty and not to conclude it. And so today we'll continue from those discussions and look at how a treaty can be concluded and how it becomes binding on nation states that have participated in the negotiations. For a treaty to become binding on a nation state, the state must express its consent to be bound by the treaty. In other words, the consent to be bound by a treaty is simply the state's expression of their approval and their acceptance of the content of the treaty. And so without that expression of a consent to be bound by the treaty, the wording of a treaty, though the states may have adopted in the adoption, may have participated, in the adoption of that text, will not be binding on the state unless they have expressed their consent to be bound by the treaty. The consent to be bound by the treaty is an essential prerequisite for the coming into force of any treaty that has been negotiated among party states. Consent to be bound by a treaty can be expressed in many ways, and Article 11 of the Vienna Convention of the Law of Treaties will provide for the many ways in which a state can express its consent to be bound by the treaty. And then Articles 12 to 18 of the Vienna Convention on the Law of Treaty will give details on all of the individual means by which consent to be bound by a treaty for a state can be expressed, and how that consent or how the consent is to be expressed in that particular chosen medium. And so let's delve right into it and begin our conversations on the expressing consent to be bound by a treaty. Article 11 of the Vienna Convention of the Law of Treaties provides that the consent of a state to be bound by a treaty may be expressed by signature, exchange of instruments constituting a treaty, ratification, acceptance, approval, or accession, or by any other means if so agreed. And so the Vienna Convention identifies 4 key ways by which a state may express its consent to be bound by a treaty. The first one is by signature. The second one is by the exchange of instruments constituting a treaty. The third being ratification, and the fourth being acceptance, approval, or accession. And then it opens it up because of the principle of freedom to contract. It opens it up that by any other means, if so agreed. It gives the negotiating states the freedom to decide by whatever means they please how a treaty can be concluded or how the states negotiating the treaty can express their consent to be bound. Going forward, we will take all of these means of expressing a state's consent to be bound one after the other, and then we will delve into them and see specifically what they provide for. We will turn our attentions for these purposes to Articles 12 to 18 of the Vienna Convention on the Law of Treaties to explain into details what all of these means that it has provided. Article 11 acknowledges what they entail and what has to be done by the party states for that expression of the consent to be complete and to be binding. The first one is consent to be bound by a treaty expressed by a signature. And that is what is provided for in Article 12 of the Vienna Convention. And Article 12 of the Vienna Convention says that the consent of a state to be bound by a treaty is expressed by the signature of its representatives when A, the treaty provides that signature shall have that effect, or B, it is otherwise established that the negotiating states will agree that signature should have that effect, or C, the intention of the states to give that effect to the signature appears from the full powers of its representative or was expressed during the negotiation. In our previous episode, we saw what full powers meant and the category of persons who would be assumed or presumed by the VCLT to have full powers. Article 12C, Article 12.1c is saying that a state may detail in their granting of the full powers how they want that, representative to express their consent to be bound. And so if in the full powers, the state states clearly and categorically that they want their consent to be expressed by signature, then Article 12 is saying that the signature would be a means by which the consent of the state to be bound would be expressed. Otherwise, paragraph A and B would give other instances where signature would be required. And A will say that when the treaty provides that signature shall have that effect, that is, when it is an express term in the international agreement, that signatures would be the means by which the international agreements would be concluded. And B, it is otherwise established that the negotiation states will agree that signature should have that effect. And B is saying that if they implied by their negotiations and by their actions that they intend for a signature to be the means by which their consent to be bound is expressed. Let us draw our minds back to the case of Brujah-Jemfi versus Attorney General, and it is a case that we saw in the earlier episodes on our discourse on treaties. In that case, the Ministry of Defense of the Republic of Ghana had entered into an international agreement with the United States government for the relocation, for the establishment of a military base here in Ghana. When the Minister of Defense submitted that agreement to Parliament, the agreement had not been signed. It would mean then that the agreement had provision or a slot where representatives of the two governments were supposed to have signed to express their consent to be bound. This agreement was submitted in its unsigned state to the Parliament of Ghana for ratification, as Article 75 of the 1992 Constitution would demand. Brujah-Jemfi, who was the plaintiff in that case, said that as long as the instrument had not been signed, it did not constitute an international agreement, and therefore it could not be submitted to Parliament for ratification. In disagreeing with this position, the court said that even if the exchange of note verbals could constitute an international agreement and note verbals were generally not signed documents, they did not think that the absence of signatures on the instrument did not constitute, an international agreement. However, if you juxtapose that decision with what is found in Article 12 of the VCLTs, Article 12 will say that if the states have provided or have acted in a way, or the full powers documents that was given to the representatives specify that signatures are a means by which the states would express their consent to be bound, then signatures would be required before such an agreement is binding on the states. It would then stand to reason, if you look at it, that in the case of Brujah-Jemfi, if there were slots or provisions for signatures by the representative of the United States government and by our own Minister of Defense, then it would mean that the states or the parties in negotiating the agreement sought to make signatures a means by which their consent would be expressed. And so if that signature had not been done or had not been appended onto the instrument, I would humbly be of the opinion or suggest that that document is not binding until signatures are appended on the document or on the instrument. The second means by which an international agreement would be concluded is by the exchange of instruments constituting a treaty. And that is provided for by Article 13, or Article 13 provides more details on what has to be done for a treaty that is to be concluded by the exchange of the instruments should be done. It says that the consent of states to be bound by a treaty constituted by instruments exchanged between them is expressed by that exchange when A, the instruments provided that their exchange shall have that effect, or B, it is otherwise established that those states were agreed that the exchange of instruments should have that effect. In other words, Article 13 is given or it's acknowledging the fact that the exchange of diplomatic notes, or even notes verbals, or of any other instrument could signify the state's consent to be bound by the treaty if the parties negotiating that treaty indicate, either in writing or by their action, that a mere exchange of those instruments should constitute a means by which they express their consent to be bound by that treaty. If you would recall, in the case of Banful and another versus Attorney General and another, the court said or gave credence to the fact that note verbals that had been exchanged between the United States government and the government of Ghana for the relocation of some 2 Gitmo detainees constituted an international agreement which had to be submitted to the Parliament of Ghana for ratification. This seems to be in line, in my understanding, with Article 13 of the Vienna Conventions, that if 2 states express that their consent to be bound should be constituted by the exchange of 2 documents, then irrespective of the lack of signatures or any other things that we may deem to be important for consent to be bound to be expressed is missing, the mere exchange would constitute a means by which the consent to be bound can be expressed. And that finds its, credence or approval in Article 13 of the Vienna Convention of the Law of Treaties. Article 14 will also provide for the consent to be bound to be expressed by ratification, acceptance, or approval. Consent to be bound by a treaty expressed by ratification, acceptance, or approval. This is very important because when we discussed full powers, we saw that certain persons only had the authority to adopt the text of the international agreement. And so that if they had the power to adopt the text of the agreements, there was the need for another body or another person to express the consent of that state to be bound. We saw that diplomatic missions, had the power, heads of diplomatic missions had the power to adopt the text of an international agreement between the accrediting states and the states to which they were accredited. But they did not have the power to express the consent of the states to be bound. Article 14 of the Vienna Convention on the Law of Treaties is then saying that if it is indeed ratification which is required for the consent of the states to be expressed, then after negotiating and concluding the text of the treaty, the representatives are to return to the sending states, submit the text of the international agreement to the powers that be, to the executive, and in the case of Ghana, to the Parliament of Ghana, to go through the agreement and approve it or accept it or ratify it before that expression of consent is concluded. All right. And so that if you do not have the power to conclude an agreement or an international agreement, then you cannot go and sign an agreement without the ratification of the people that have sent you to represent them. And so in the case of Ghana, Article 75 will say that after the conclusion of international agreements, the executive would have to submit the international agreement to Parliament for ratification. Article 14 is saying that if ratification is required, then the persons who have represented the state must take the instrument of their international agreements back to their respective countries and get the authorities to ratify the agreements before it becomes binding on them. Article 16 of the Vienna Conventions will then go on to give what has to be done after the ratification has been done in the individual or their respective states. Article 16 will say that exchange or deposit of instruments of ratification is to be deposited at the venue of the discussions of the treaty, where the treaty was discussed and finalized, or some other designated place. These instruments of ratification will then have to be deposited there or has to be exchanged there for the parties to know that they have received the full acceptance of the authorities of the party states involved in that ratification. And so in the case of Ghana, when the parliament approves or ratifies the agreements that the executive has entered into, they would issue an instrument of ratification which will be signed by the authorities. That instrument is then deposited at a place that is designated by the treaty to be where the instrument of ratification must be deposited. Or the representatives will then exchange their instruments of ratification amongst them to signify the coming into force of the international agreement for which the consent to be bound by the agreement was to be expressed by ratification. The last but not the least means by which consent to be bound by a state can be expressed in any international agreement is when the consent to be bound by a treaty is expressed by accession. And it says that the Article 15 of the Vienna Convention will provide that the consent of a state to be bound by a treaty is expressed by accession when A, the treaty provides that such consent may be expressed by a state by means of accession, and B, it is otherwise established that the negotiating states were agreed that such consent may be expressed by that state by means of accession, or C, all the parties have subsequently agreed that such consent may be expressed by that state by means of accession. Accession comes into play when a treaty has already been concluded between original parties to a treaty, for want of a better expression. So let's say that the ECOWAS is a treaty that was signed by states of West Africa, all right? And we expressed our consent to be bound by that treaty. We negotiated the terms of the treaty and we signed that international agreement. Subsequently, states which did not participate in the original negotiations for one reason or the other, probably maybe they didn't have independence or they didn't agree with the terms or they didn't think that signing such a treaty was beneficial to them. If subsequently they have a change of mind and want to be bound by that treaty or become a state party to that international agreement, the means by which they can be bound by such an agreement which has already been concluded and finalized by the original parties would be by accession. And accession is becoming a party to an international agreement after it has been concluded and has come into force. So let's say that a country like Rwanda, who is not a part of ECOWAS, subsequently deems it important to belong to a sub-regional body and has chosen to break away from this, Central African States Association and wants to join ECOWAS. Then Rwanda would have to do what is called accession, accede to the ECOWAS treaty, and then they would be deemed to be a member of ECOWAS going forward after the accession is accepted. However, Article 15 is saying that the party states which originally negotiated that treaty and signed that treaty must first and foremost acknowledge that that state, which is Rwanda in the example we have given, has the authority or is capable of becoming a party state to that treaty by accession. And that is what Article 15 provides for. We saw also that Article 11 provides that in the spirit of the freedom of contract, party states that are negotiating an international agreement can on their own devise their own means by which their expression to be bound by that treaty is to be expressed. And if parties do that, it does not mean that because it is not one of the four that we have discussed, it will not be valid. Article 11 of the Vienna Convention gives validity to any other means by which the negotiating states would want to express their own consent to be bound by that treaty. And so, viewers, in this episode, we have discussed consent to be bound by the state that has participated in the negotiation or the adoption of the text of a treaty. We have seen that Article 11 of the Vienna Convention of the Law of Treaties provides for four main means by which express consent to be bound by a treaty may be expressed by a negotiating state. And those are 1, by signature, 2, by exchange of the instruments that constitutes the treaty, 3, by ratification, and last but not the least, by accession. In all of these, all the articles that we have seen which provide for the individual means we have just spoken about, what runs through them is that the states are at liberty to choose which of the four means by which they want to express their consent, or even Article 11 would give them the opportunity to devise their own means by which they express their consent to be bound. I hope that you have found this session very informative. If you have any questions, please do well to leave them in the comments section, and we will be more than happy to address them in subsequent episodes. Thank you very much for your attention and for making time to watch this video. Please like and subscribe to the Law Lab platform. There are more educative videos we will be sharing going forward to help us understand the legal principles that we are learning in our own LLB programs, or for the general public who want to understand some of these legal principles we discuss here. My name has been Adamu Ben Mahmoud, and I hope to see you again soon. Thank you and have a good day.